Welcome to The Point of View. This is your favorite current affairs show on television. We're live tonight on the biggest case in Ghana. The ambulance matter has had a very seminal judgment. The Court of Appeal has upheld the appeal by the first and third accused in the case, who say the trial judge's decision that they should open their defense was not correct. So tonight we're going to talk to two lawyers on what all of this means for the ambulance case and all the politics around that matter. We're live, so send us your views. I have two very interesting lawyers. I have Bobby Bunsen, who's in studio with me. Bobby, good evening.
Good evening, Bernard.
Great to have you.
Same here.
And I also have Justice Femsai, who's joining us virtually. We'll take a breather. When we come back, we're jumping straight into what the core issues are, who are the key personalities, what did the Court of Appeal look at, and we'll look at the key issues that they agreed and disagreed on, and where that leaves this very controversial case. Stay with us. Welcome back. So tonight it's very legal, but the people I have on the show will make it very simple for us. Bobby Bunsen, I hope you're not going to complicate matters.
I will not.
Not complicate. But you've been following this matter closely, right?
Yeah, sure.
For a lawyer like you, seeing a case have a camera in, like basically the cameras are in the courts, and at some point the protagonists were granting interviews. What did you make of that? How politicized it's become?
Well, because of the personalities involved,
Yeah.
I think the new dynamics would be the fact that it's the first time in recent history that we've had the Attorney General personally being put in the spotlight, not necessarily because of the discharge of his work in the courtroom, but his conduct outside the courtroom. I think that brought a lot of attention that I believe could have been avoided with hindsight to this case. But I mean, it also shows the extent to which our democracy is developing, the extent to which people are becoming more and more interested in what is happening, where our money is going, what the politicians are saying.
Yeah.
They can make a judgment by themselves, listening to what the judges are saying, what the parties, what the lawyers are saying. So it's interesting. There's nothing else you can hide.
Yeah.
People are becoming more educated. They will be able to understand the things for themselves. And I think it's a plus for our democracy.
I don't know if I have Justice on. Justice, are you on? Good evening. Okay, I'm not sure if I have him. But I'm sure the kind of pressure this puts on the trial judge will be enormous, right? Because you have a political party like NDC holding a press conference on the case, then Van Davis and the MPP also hold press conference, and then they allow camera in the court. At some point, she says no more interviews. I mean, I haven't seen a case like this in a while.
For a trial judge, normally, I mean, you're a human being, you would expect that some of these things, at least you hear them. You cannot deny the fact that you live in a society. But if there is any judge that I believe would be able to take that pressure, I wouldn't go beyond justice. I mean, when I started practice, she was, let me say, the head of the Attorney General's office in the Ashanti region, and you should see her doing prosecution. She was wild. I mean, and she would not be intimidated. She will believe what she believes in, she's going to say, she's going to do. She may not be right, but at least you can be sure that is what her conviction is.
Wow.
And then she'll do it without fear or favor, irrespective of, I mean, for her to look straight into the Attorney General's eyes and tell him that, listen, if I were you, I would not be personally involved in this matter.
A seminal after the leak tape, and she advised him, but he decided not to. Speaking of which, let me show viewers the key players, all right? So this case is high profile because, of course, Godfrey Dame, as Bobby has said, the Attorney General is personally the one on his feet in court. This is not ordinary. Usually they would have their deputy or chief state prosecutor, so this is significant. Then, of course, first accused Kaziel Atuforsen, you can also call him the appellant one, because in the Court of Appeal matter, he's the one who's appealing, but he's the first accused. He was spokesperson for finance when the trial began. Indeed, this whole controversy began for transactions done 10 years ago. Today is 31st July. This was between August 2014 and 2016. So the alleged crime is 10 years old. Atuforsen is not a minority leader. He's the first accused. Now, Sylvester Anemana is the chief director of the Ministry of Health at the time. He was discharged.
He was discharged.
So at this point, has no case to answer, but he was second accused. Richard Jakpa, is the third accused, and he's the gentleman who had the phone call with Godfrey Dame with all the controversy. Alex Ebefia is in this matter because he's former Minister of Health, and the key issue is somebody wants to procure ambulances. Health Ministry is in charge. The opinion he preferred about the quality of ambulances is very important to the Attorney General. The person who authorized the letter of credit is the Deputy Finance Minister. Big C is the company that did the supply, and he is their local representative. So this is how this whole thing works. He's the Attorney General. He says this guy authorized payment for deficient ambulances supplied by these people that this guy said was not good. This gentleman was the local rep of these people, so he also stands accused. Causing financial loss to the state is the big thing. Key person missing here, his boss, Setekpe, because he's a deputy minister. Setekpe has not been called for some reason because he said openly that he authorized this. He is saying we have to take these people's view because they are the guys who use the ambulance. The ambulances are still there. So those are the key issues. Now, how did we get here? Just to explain again, the 3 accused were sent generally to court. So you want to make what is called a prima facie case. So Attorney General goes to court to say these 2 cause financial loss to the state. These 2 say the evidence he had used is not enough. So
he originally went with these
3. And they initially said, I don't have enough evidence for this guy.
Yes.
So he drops this guy and says, I'm going to use these 2 or accuse these 2. After he makes his preliminary case, these 2 people say, look, he hasn't adduced enough evidence for me to even open my defense. He hasn't made a prima facie case. So trial judge, declare no case. She says, no, I think a prima facie case has been established, so open your defense. Then these 2 go to Court of Appeal to say, no, that's a miscarriage of justice. This guy hasn't adduced enough evidence. So where we are today is that the Court of Appeal has sat on the decision to dismiss the no case that these 2 filed. But the key issue is that while this Court of Appeal was deliberating, the substantive matter was going on. Yeah. The tape and all the confusion, it had traveled a mile. All right. So today we are going to analyze what His Lordship Justice Akabuafo, Justice of the Court of Appeal, Justice Pokwe Champong, the presiding judge, and Justice Mensah. It was a 2-1 decision. Mensah and Akabuafo agreed as Cassiel and Richard Jakpa. They say there's no case to answer. Presiding Pokwe Champong says there is a case to answer. This is why we're here. Beautiful. So what I want to do, I'm going to give you quick summaries of what the justices said. So let's start with Kweku Akabuafo, who was the main, if you want, he delivered the main judgment. Yes. Yeah. So the first thing he says, I think you should start with paragraph 106. He says, I'm of the view that the prosecution failed to provide sufficient evidence that meets the threshold of connecting the first appellant, Ato Forson, to the offense he's charged with and relates to the ultimate of proof beyond a reasonable doubt. So that's the first thing he said. Then paragraph 71, despite the very clear and unequivocal answers above that an LC was not a payment but a guarantee, the current health minister, or at the time, the health minister, Jimamenu, before Okoboy took over, gave a different answer on the August 30 when he said that per the terms of the contract, payment should have been made or done by LC. So basically, one of the key issues here is a letter of credit, which essentially is a bank saying that let the transaction go through, I will pay. There's a confusion as to whether if Ato Forson issues a letter of credit to a company, it involves a payment for which you should say financial loss has been caused, or is just a guarantee that when the conditions are fulfilled, then I'll pay. So that's a very key thing. It seems as if this dismissal of the, or this overturning of what the trial judge did hinges a lot on what a letter of credit is. Do you get that impression?
Yes, obviously. I must say you're using more legalese than...
Oh, forgive me. I'm trying to get my people on the same wavelength.
Yeah, I understand. It's good. I think the start-off point is to read the charges.
Wonderful.
And then the particulars of facts. Because at this stage,
what
the trial court did, which the appellate court redid, for lack of a better word, was to see whether the evidence that had been led by the prosecution at that stage matched the charges that had been led.
Wonderful.
And so, for example, for Honorable Ato Forson, the first charge was willfully causing, and the words, willfully, It means intentionally
Cause.
causing financial loss to the Republic.
Yes.
Now listen to the particulars of offense. You, Kesel Atoforsen, between August 2014 and April 2016 in Accra, willfully caused financial loss of 2.37 euros to the Republic by authorizing irrevocable letters of credit valued at 3.950 to be established, out of which payments amounting to 2.370 were made to Big C for the supply of vehicles purporting to be ambulances without due cost and authorization.
Wonderful.
Now, if you look at these particulars of offense, there are three elements that the Attorney General or the state was required to provide evidence of
To back.
at that stage. One, whether or not at the time Kesela Toforsen was authorizing the LC, he knew or ought to have known that the ambulances were defective.
Wonderful.
Two, whether or not the fact that he authorized the LC meant that he also authorized the payment.
Wonderful.
That's the second element. And then three, whether or not the payments, the authorization of the LC that he did in his position as Deputy Minister for Finance was with the authority of the Minister of Finance. These are the three elements. And so if you look at if you read through the judgments, all that the judges were doing at the appellate court was to determine whether or not the evidence that were led so far established whether or not, one, at the time Mr. Atoforsen was authorizing the LC, he knew the ambulances were defective. And so you have one judge saying that, listen, how could he have known? It is the Ministry of Health. And so you cannot say that he knew at the time he was authorizing it. Three, whether or not the fact that he has authorized LC means that he is authorizing the payment.
Wonderful.
And that is where, like you said, the evidence of Honorable Ajima Menu was very key. Because when he was asked under cross-examination, if you issue an LC, is it payment? His answer was very categorical from the beginning, from the record that was adduced. First, he said, yes, it means you are saying payment ought to be made. Now, further down the line, he says no. And so that is where the judge said his statements are inconsistent, because the fact that you've authorized the LC to Bank of Ghana, he's saying that if these conditions are met, then payment ought to be made. Now, who would satisfy whether the conditions are met?
Is it the paying officer
or the Ministry of Health?
Very good point.
That is what the judge was looking at. Now, the last one, whether or not as Deputy Minister for Finance, he had the authority to authorize the LC.
Wonderful.
And the judge said, and that is where you see, that is the main point of dissent between the judges.
Yes.
Whether or not, who has the burden to prove that he had the authority? Whether it is the Republic, because per practice and procedure, it is the minister that ought to have authorized it.
Yes.
In his absence, he must expressly authorize the deputy or the chief director to sign the document on his behalf. Now you have the trial court judge saying that, listen, it is since the state says that he didn't have the authority, they don't have any burden to prove. But since Mr. Atoforsen is saying, I had the authority,
he should prove.
He should prove. That is what the trial judge, which the dissenting judge at the appellate court agreed.
Yes.
But the majority of the Court of Appeal said, listen, the accused person in criminal proceedings has no burden at all. So if you look at Justice Akabuafu's preliminary or opening statement, he said that the accused person has no burden to aid the state in prosecuting him. So if you say that he did not have any burden, he did not have an authority, you should call the said minister to come and say that I didn't authorize him.
And yet you haven't asked Mr. Tekwe to come
and testify. So for the majority of the Court of Appeal, Mr. Tekwe was a material witness.
So if Mr. Tekwe, if the state had gotten Tekwe to testify and Tekwe had said, I did not authorize, then they would have their evidence.
Exactly.
So don't force Atoforsen to incriminate himself.
He has no burden to say anything.
So Akabuafo and
Mensa said the burden was on the state. That if the state had failed to call Mr. Setekwe, who was a material witness, then the state has not established that second element.
Very interesting.
So from this charge sheet, those were the three elements that the evidence adduced were being tested against, to see whether at the close of the case of the Republic, they had established a prima facie case. And then you would have, unfortunately, or sorry, as it were, the decision of the Court of Appeal was not unanimous. One saying no, the burden was not on him. I think there's prima facie case. The other two saying no, he had no burden, and then there was no prima facie case.
Which is why in paragraph 71, Akabuafo comments on Ajima Menu's answers. So on the issue of letter of credit, so you're saying this case, the letter of credit and its effect is very key.
It's very, very important.
The authorization for payment is very key as well. And then, of course, the third one will be Mr. Jakpa and the obligation for him. I just wanted to walk through some of the things the first Court of Appeal judge said for the sake of following. So if you can put up, for example, paragraph 76, where he talks about the financial loss to the state, and then paragraph 91. If you have those, please put them up for me. It will help me just to walk through them if you have this for me. So, what about Mr. Richard Jakpa in all of this? Is it the same issue, or where is?
In fact, he was charged under a different law, not causing financial state. He was charged under, I believe, an SMD saying that he had misappropriated
so they
public.
Said between August 2014 and April 2013 in Accra, in the Greater Accra region of Ghana, he willfully caused financial loss.
Yes, that was 2.3
to the Republic by intentionally causing vehicles purporting to be ambulances to be supplied to the Republic of Ghana by Big C of
and
Dubai
then
without
count 5.
due cause. Intentionally misapplying public property contrary to Section 1(2) of the Public Prosecution Act 1977 SMC Decree 140.
Yes. So these were the two charges that were leveled against him. Now for him, the interesting thing is he was only an agent. And his principal, which was Big C, was there. Now this becomes very interesting because you would recall that as soon as the trial started, Big C offered to reimburse these amounts, I think 2 million or so, to the states so that the prosecution would truncate. Even though Big C, which is the principal, for some reason,
it's not part of that.
It's not part. I don't know the reason why Big C or the directors of Big C, even though they may not be in Ghana, but
so why the agent rather is the one who stands accused?
That was the question that was asked. For him, he only had an agency agreement, introduced his principals to the state, and the fact that he had been paid his commission, which I somewhere along the line seems to suggest that he even had to go to court for a court order to be made for his commission to be paid to him. Why do you then bring charges against him for purely engaging in a commercial transaction? He introduced principals to you, and then the fact that he had submitted to you what his principals have said. So whether or not you can hold an agent liable for acts of a disclosed principal, those were some of the considerations by the judge. And so the moment that you are not able to hold the charges against Mr. Atoforsen against him, it will be very difficult to hold the charges that you have brought against Mr. Jakpa against him.
Put paragraph 154 up before I talk to my next guest. So based on everything we've said, concluding and coming to his judgment, the first of the three justices, based on the above analysis and infidelity to the law, I'm of the opinion that the appeals filed by both the first and third appellants should succeed. In the result, I would allow the appeals and their ruling and the ruling of the trial court dated March 30, calling on the two to open their defense to be set aside. So basically saying, I disagree with the trial judge, I agree with Atoforsen and Jakpa. Also, the call on Jakpa to open his defense in respect of the charge in count 3 is set aside. In their place, an order upholding the submission of no case entered for both the first and third appellant in respect of those 3 counts in the charge sheet are issued. Consequently, both appellants are hereby acquitted and discharged. So this is the first. Now, I'm told that when it comes to a court of appeal, you have an odd number.
Yes.
So that there's always going to be, because you don't want
a majority.
So we'll come to Justice, the second one shortly. But let me talk to Justice Sremsai, and his name just is not because the judge. It's just his English name. Dr. Sremsai, thanks for joining us. How are you? Can you hear me? Can you hear me?
Yeah, I can hear you.
Wonderful. So my colleague in the studio is basically saying that there are three issues here: the letter of credit issue, the authorization issue, and then possibly issues around agency and principal for Jakpa. Do you agree that the case hinges on those three key issues?
Yeah, that is true. Yeah, the case it revolves around these three issues. The first issue being what really is the effect of issuing a letter of credit. Does it amount to actual payment, or does it include some conditions which ought to be satisfied before a payment is made? And if it includes some conditions that ought to be satisfied before a payment is made, then the question is, who are the persons who satisfy these conditions? So that is the first issue. Then on that issue, it appears the High Court held that the authorization of the letter of credit is enough evidence of actual payment. So if you read the judgment of the Court of Appeal, you will note that the two sides, that is the majority and the minority, were divided on that issue. The minority judge was of the view that once you authorize a letter of credit to be established, you have irrevocably authorized payments, and by that act, you are responsible for the payment, so that when you make the payment and there is a loss, you squarely are the one responsible for that loss. But when you look at the reasoning of the majority members of the panel, they hold the view that a letter of credit is really not payment by itself, because every letter of credit has some conditions that you would have to satisfy before it is paid. So the mere fact of establishing a letter of credit is not automatic that payment will be made. And when you go into the law regulating the letters of credit for such instruments, you will truly find out that there are conditions which ought to be satisfied before. A typical example would be that you would want to certify that the work itself has been done, and you would have to present some documents, some of which include what we call payment certificates for the letter of credit to actually be paid. So if you put all that together, you will see that to a very large extent, authorizing a letter of credit to be established may not necessarily be a direct payment. So that is the point of departure between the minority judge and also the majority. Now to the second issue, which
before I go to the second issue,
a very technical part of the judgment, which
Justice,
is quite interesting, because if you read the judgment, you realize that the two sides produce authorities to suggest that you have to, the person who bears to suggest who bears the burden of proof. So, for example, we know, and I think that's the general knowledge out there, that when you allege, you prove. When you allege that someone has done something, you have to prove. And so that is the general rule, but there are exceptions to that rule, which says that sometimes an allegation, and the nature of the allegation may require the person who is being accused to rather, prove those, the negative of the allegation. Now, the question which the court had to deal with was whether this particular situation is one which requires the one who is being accused, that's the accused person, to prove that he was authorized. Now, let's go. The authorities suggest that where the evidence in question or the fact in question is in the exclusive possession of the person who is being accused, then ordinarily the burden ought to be on him. So, for example, if I wake up today and I said, and the question is whether I had a dream, the evidence of proving whether I had a deal can only exclusively be in my exclusive possession. It cannot be Bernard to your possession. So it will be unfair for you, Bernard, to be asked to prove whether I had a deal. You get the point?
Yes.
So, but in this case, the question which the court was facing is this one of such instances where the evidence is in exclusive possession of the first accused. It appears not so, because as we have seen, there are, at least the answer to that question, whether there was an approval, to be heard from Mr. Tepe. If it could be heard from Mr. Tepe, then the question which the majority followed up was, if Mr. Tepe is around and he can provide that evidence, then you cannot compare an accused person to incriminate himself. And so why didn't you call a material witness to come and provide the fact that you need to certify that there was a question of authorization? And so the majority held a view that to the extent that you refuse or you fail to call a material witness who is available to prove a fact, you cannot, under the circumstances of the law, under the rule of law, compel an accused person to speak. And at the end of the exploration of your case, when you end up exploiting your case, you have not proved that. And so when you look at the things that a prosecutor is supposed to prove to be able to call on behalf of the defendant called over, one of the requirements is that you should establish all the elements. And there's another one which says that if the testimony leaves the question, evenly balanced as to whether there is a guilt or there is innocence, the judge must uphold the submission of no case. So the majority of the panel were saying that as to the authorization question, it is as if it's still open. You have not got any evidence to say that he was not authorized. And you are saying that he has to wait and be called upon to show or to prove that he has been authorized. So it is an open game. And the rule, if you look at the authority that we cited, all the authorities say that when such a situation of prison, when the issue is open as to that guilt or innocence, then that this person must be charged. So that was the issue of the authorization. Now let's go to
Justice. Hold on. Can you hear me?
Let's go to the.
Can you hear me?
Yeah,
I was going to ask two quick questions around the first point. So the letter of credit matter, the trial judge basically says that the letter of credit is a payment. That's the way she saw it, right? In the first issue of letter of credit. Now, I just wanted to know whether the decision to dismiss the submission of no case, was it done before all the evidence was adduced, or this was at the beginning of the trial? Because if you listen to Akabuafo closely, the testimony of Ajimamin was very key in the way he decided to interpret the whole letter of credit issue. But so my question is that, can we pardon the trial judge because at the time she made some of those decisions, this was at the beginning of the trial, and that it was when the substantive matter became sort of hot, and then various people were called for evidence that all of these things were emerging. Is that a fair proposition?
Well, I think that you see, that particular question, I don't even think that it is a question of fact which is inherited from a witness. Whether a letter of credit is payment or not is a question of law. So there is a law, a body of laws that regulate these instruments. You understand? So I don't think that is a question which we need to rely on a witness to answer, because the law there's a legal position of what a letter of credit is, and so that wouldn't change much. The testimony of Mr. Demamenu definitely is helpful, but even if he had answered it the other way, he doesn't possess or he doesn't have control over the law on letters of credit. So his answer would have been immaterial, the conclusion whether a letter of credit was in fact payment.
Wonderful. I'll take a break. When I come back, we'll do the Jakpa issue. This is the point of view. We're talking the ambulance case, the Court of Appeal's very, very consequential judgment and the AG's decision to appeal this particular judgment. My guest, Bobby Branson, a lawyer, Dr. Justice Remsai, also a law lecturer. We'll be right back. Stay with us. Welcome back. Point of View tonight is trying to break down the very, very seminal judgment of the Court of Appeal, where a submission of no case, or essentially a request for no case, which was rejected by a court, for which reason the whole case was being heard, has now been upheld by the Court of Appeal. 3 justices, Justice Poku Echampong, Justice Mensah, and Justice Akabuafo. My guest, Bobby Branson, private legal practitioner in studio, and I have joining me virtually Justice Remsai, who's a law lecturer. I want to give you some highlights of what the second judge said, Justice Bright Mensah. So, look at paragraph 79 and look at that. It says, I am of the considered opinion that Setekwe was a material witness whose evidence would have decided the case one way or the other. Failure to invite him was fatal to the case. Think about it. Ajima Menu is the health minister now. He was there. Health minister then, Alesebefia, I don't know if they called him.
No.
He's not been called to talk. The boss of Atufosin, Setekwe, has not been called. The principal for the Jakpa's agency has not been called. So it seems as if these judges are saying, look, if you really want to get to the bottom of this matter, there are some points you should have brought in. Don't push the thing on one guy. I don't know what to make of that. It seems like some miscalculations there.
Well, they were guided by the principle that the accused person or persons do not have any burden at all. And so you do not come and throw things at them and say that you must prove that they are not guilty. I think that was essentially, if you want to break it down barely, that is what they were saying, that they, in their opinion, the Attorney General just came to say, okay, we wanted to buy ambulances. You came to tell us the ambulances could do A, B, C, D. We have paid you 2.3 million. Now tell us why the ambulances could not do A, B, C, D. Meanwhile, you, the Attorney General, must provide evidence to show that they knew the ambulances could not do A, B, C, D at that time. And the majority of the Court of Appeal felt that the Attorney General failed to call the material witnesses. And we can't fault the Attorney General for not calling those people, because obviously, prior to this or even in the course of this, we've heard Mr. Setekwe saying that, listen, I authorized him.
So then what's the point of
prosecuting? Now the Attorney General is in court saying you did not authorize him. So you can't call him, because if you call him as your witness and he comes to say that I authorized him.
So then what's the point? Let's go to page 74. And some of what Justice Mensah says, pretty damning. He says, I've critically examined and all the evidence led on record, both oral and documentary. The evidence in chief, each witness of the prosecution offered, and cross-examination of the witnesses by defense counsel. Here's my emphasis. Upon a very passionate reflection of the evidence and arguments of both counsel for the appellant and for the Republic, it is my respectful opinion that the evidence in its totality is so unreliable that no reasonable tribunal minded to do justice could safely convict upon it. This is very serious. Listen to the last part. He says, the evidence in its totality is so unreliable that no reasonable tribunal. So what's he saying about the trial judge?
Well, you know, when they...
this is serious.
When they make such comments, they are not necessarily attacking the judge.
They are talking about the overall prosecution.
Overall prosecution.
But you see, of course, that's why I was asking the question about whether the trial judge refused the no case before the evidence was all fully adduced, because it was a primary facie issue.
Yes, so this is the procedure. When charges are read, the plea is taken. After the plea is taken, the prosecution would have to adduce all the evidence.
In writing?
No. Call your witnesses. So you do your witness statement, then they will come and then they will be cross-examined by the lawyers for the accused person. When they finish and you, the prosecution, you say, I have closed my case. At that point, the judge is obliged by law to look at the evidence that the prosecution has led so far to see whether or not the evidence supports the charges. If the answer is yes, then they will ask the accused person to open the defense. What the judge is now saying that Mr. Accused person, from what I have seen, I will convict you unless you convince me otherwise.
So come and open your defense.
Come and open your defense. If the judge, after looking at the evidence that have been led, they do not match the charges, then the judge will say, I don't even have to call him.
There's
because
nothing
you
here.
brought him here, and the burden is on you to prove beyond reasonable doubt.
So Justice Mensah is saying that after looking at all the evidence adduced and upon cross-examination...
That was before the defense,
Yes.
the accused person
So he said when they
opened
looked
their
at all the
defense.
evidence,
Yes.
no reasonable tribunal minded to do justice could safely convict upon it. I think that's very strong.
Yes, it's
That's a
strong.
very strong thing
You know,
to
the
say.
reason why in criminal matters, the judges use such strong language is because if it had gone the other way around, this is somebody's personal liberty being taken away from him.
Yeah.
And then the golden thread is that it's better for 1,000 guilty persons to walk free than for one innocent person to be in prison.
Wow.
And so they are very passionate when it comes to, and it's not because of the personalities involved.
Yeah.
If you read most judgments in criminal jurisprudence, you see that the judges use such language because it's the human rights of somebody that you are attempting to take away. So the threshold is very high, irrespective of who is involved.
Look at paragraph 80, page 80. Also very, very serious thing to say. He says, I think the lower court fell into serious error, occasioning a gross miscarriage of justice to the appellant because his duty is only to raise doubt in the case of the prosecution. So he's like, no, you got it wrong. You got it wrong. And then, I mean, I feel like, and what surprises me is that, of course, the dissenting minority view also strongly believes that the trial court also was right.
Yes, and if
So
you read,
this is very serious.
You see that they all use the same authorities, the same cases. So all the cases
Wow.
that the majority relied on, the minority relied on almost all of them except one or two. So that's the beauty of the law. The same facts, the same principles of law, but different conclusions, depending on how you perceive
Show
the
me
evidence.
81 and then 85 to wrap up, and I'll go to the last judge. 81 says, it is beyond any serious dispute that the applicant in the LC application was the Ministry of Health. This is 81. Okay. Yes. It is beyond any serious dispute that the applicant in the LC application was the Ministry of Health. As the applicant and beneficiary of the LC, it was the duty of the Minister of Health to do the necessary pre-shipment inspection to be satisfied with that the ambulances being imported met the requirements. It was not the duty of the appellant to force him to do so. And yet they didn't call Alessandro Befia.
No, they didn't charge him.
They didn't even charge him.
Yes.
Because he didn't. So I think the AG is thinking of he didn't make the payment. But
He's the one that was supposed to check whether the conditions in the
But he also,
LC
AG talks about a letter Segbefia wrote about or allegedly wrote about the ambulances, which he supposed said that the ambulances were defective.
Yes, but at what point in time was the letters written? Because you recall that there was an opinion from the Attorney General's office
Yeah,
saying that the people have satisfied
wonderful.
and so they ought to have been paid. And if the Attorney General is the principal legal advisor to the government,
Yeah.
and he has written such an opinion, then as the minister,
Obviously.
what else can you do than to...
Show me 85. Let me end with Justice Mensah, 85. It says, it's my respectful opinion that there has been no evidence to prove an essential element in the crime, or that evidence was so manifestly unreliable that no reasonable tribunal minded to do justice in the matter. I think this is very strong. All right, let me look at the dissenting, or I call it the minority view. So go to Justice Alex Pokwe-Champong, and which is quite interesting with law, because you think that these are colleagues on the bench, they are using the same authority, listening to the same evidence, reading the same case. Look at what he says. I do not think that the trial judge's decision has occasioned a miscarriage of justice to the appellant. I'm emboldened in this view by the fact that this decision was made after the court had established the essential ingredients of the offense of causing financial loss. And you said there were at least 3 essential ingredients.
That was supposed to have been
So
satisfied.
he believes that the court established this.
That the Attorney General at that stage had established evidence or had provided evidence that established each of these elements. And so it was now the burden of the accused person to dislodge this prima facie evidence or burden that had been satisfied.
And then look at 113, page 113. I'm persuaded from the evidence adduced that there were fundamental defects to the vans supplied, so you go into the substance of the matter, and they cannot be used as ambulances. The letter of a former Minister of Health, Alessebefia, that the vans were not fit for purpose and that they were ordinary vans being passed off to the ministry cannot be taken lightly. But your point is that we should look at the timelines for that. Look at the previous Deputy AG, this letter and the payment. The timeline is crucial,
it's very
not
crucial.
just the letter taken in
it's
totality.
Very crucial. And whether or not the letter that was written, whether it could, because the person who wrote the letter was not called to testify, whether you could rely on that letter that you didn't alter.
What he was referring to. So we'll come and wrap up on that, because there are a few more things he says which are completely opposite to what the two other judges have said, which is the beauty of law. I'll speak to Justice too as well. This is the point of view. Tonight, we're trying to break down the law. My friend Bobby Banson and Justice Fremsai helping us do this. Stay with us. Point of View is live. My guest, Bobby Branson, who is a lawyer, Dr. Justice Fremsai, a law lecturer. We're looking at the Court of Appeal and the upholding of the appeal by Atu Forson and Richard Jakpa. My guests agree there are three issues around which the case hangs. The issue of the letter of credit, the issue of the authorization to pay. The last one has to do with Mr. Jakpa and his obligation, because he's an agent of a principal called Big C. Mind you, it appears this case is all around who was not called. So Tekwe, Atu Forson's boss, was not called to testify by the prosecution. Alessebefia wrote a letter. He was not called. He wasn't even accused, of course. Then you even have Big C, the company that actually supplied the ambulances, also not accused. Now, Justice, what are your thoughts around the whole Jakpa issue and why Big C was not called? Because as you can see from the screen, he is just an agent for a company. What are your thoughts around that?
Yeah, thank you very much, Bernard. I think the ultimate message in this case is that the fact that there is some law or something wrong has been done doesn't mean that we can just bring anyone to court to be punished for that which has been done wrong. I think that is the ultimate message in the decision. So if a company, so in this case, the court, the majority opinion was that, look, you have a contract between government of Ghana and another company called Big C. Now, you claim that Big C has supplied substandard, items to you, and for which reason there is a financial loss of interpretation of state property. Now, the person you have a contract with, the company which has obligations under the contract, is not before the court. Mm-hmm. Rather, he went for an agent who you know very well was working for and on behalf of that, that company, and you put the agent before the court to be convicted. So there was no connection between the person who was brought before the court and the person who contracted, and the government. The connection is rather between the person who is before the court and the counter, this is the principal. So the court was opinion that the majority view was that you couldn't have, you couldn't put this person before the court and convict. Now the minority opinion went on to say, it said that, look, this person has been involved in all these transactions. And so if you look at I think the latter part of the decision of minority opinion, a number of activities were listed as activities which the Mr. Jakpa was involved in. And for him, this is now to put him before the court for trial, and this is now to convict. So you will see that he listed Mr. Jakpa's involvement in, that if you go to page, that's page 124. Mm-hmm. Page 124, the minority opinion said the third accused in his role as an agent of the principal was responsible for the distribution and sale of the judicial in Ghana and other African countries. So the judge listed 4 instances where we believe that those activities were enough to be convicted. But when you read the majority opinion again, they will agree that this person, though, is an agent and would have done all this. We all know that an agent doesn't have much of his own skill. And so the right person to have been brought was the principal and not the agent. So that was the first opinion on that issue.
So it's quite clear that the choice of witness to call by the prosecution or the decision not to call some people also affected their case. The absence of Setekpe, absence of Big C were quite serious. You think so?
Yeah, it was. I think that was the basis of everything. That you brought the wrong people before the court to be tried, and you caused the wrong witnesses to testify. So if it comes to the issue of authorization, I mean, clearly the court was of the opinion that there's a material witness who should have been brought. Who was the minister? Mr. Sekete. Mr. Sekete is alive and is willing to testify. So why is he not in the case? And like my colleague in the school said, before even outside the court, Mr. Sekete had said already that he gave the authorization. Then again, we wonder why, if Mr. Sekete had already said outside the court that he gave authorization, obviously when it comes to the court, just really we say he gave authorization. So even if we should assume, that the burden was on the accused person, okay, to show that he has authorization, we can foresee and foretell that so long as the principal, the material witness remains in the paper, his opinion or his testimony in the court was going to affect, the accused person anyway. So then you wonder, even if you appeal these things, and that is where the appeal is coming in. Even if you appeal these things, and the court said that, well, prima facie case has been established, so it will go trial. This same authorization issue is going to come back in the trial. Where obviously the accused person is going to call Mr. Sepe, so you then come and say, I gave authorization. Then you ask yourself, what then happened? So I think that the core issue here is what kind of people, what was the criteria for selecting that accused person, and what was the criteria for selecting the witnesses that were presented in the court?
All right. Thank you, Justice. We appreciate your insights. Justice Ramsai, doctor, is a law lecturer at the, I think it's Jakpa.
No, it's not.
Ghana School of Law.
No.
Where?
University of Ghana.
University of Ghana. Okay. Thank you, Justice. Let me end with you. My concern is the way this is it's almost like a very contentious decision, 2-1. This may not be the end of the matter because the AG says it's going to appeal this. And if you have 3 respected judges, 2 say yes and 1 says no, if you go to a different panel, it may still be split, right? So my point is that this is not over.
It's not over.
It's not over.
Not at all.
It's not over.
For the sake of the law, I would wish that the Attorney General actually appeals, particularly on the point at what point does the burden shift? Because you would say some school of thought says that he who asserts positively has the burden. There's no burden on the negative assertion. They say there are some exceptions. It's only the Supreme Court
that will tell us.
that can tell us whether the exceptions are here or not. But I must be quick to add that even though the Court of Appeal ultimately upheld the appeal filed, it's not every submission that was made by the accused persons or the appellants that was upheld by Justice Akabuafo. So for instance, Justice Akabuafo struck out almost all the grounds of appeal that was filed, but ultimately rested the decision on the grounds of whether or not the submission, yes, the submissions were supported by the evidence that was adduced. They also had the ground that the charge sheet was defective because a wrong section was used. And Justice Akabuafo said, listen, no miscarriage of justice had been occasioned you. So it is not as if they just upheld everything.
So it probably then gave more weight to some of the grounds.
Yes.
So that even though a few, of course, maybe some of the grounds may be frivolous, to just add to the number. Because if you look at usually how lawyers do things, the main grounds will be the substantive one.
Yes.
And then there will be others he adds to sort of, to pad it. So your point that even though he dismissed some of the grounds, the most important grounds, he agreed.
He agreed with
which
them.
was why he
gave to the conclusions that
Wow.
he gave. So it will be interesting that to see how, if the Attorney General indeed files the notice of appeal, how it will go. Now, the practically, and you know, the main trial had truncated because of this decision. Now, when there's an appeal, what does that mean?
So we have to pause the main trial.
It's not
Okay,
paused,
no,
it's been truncated.
Yes.
As an it's been
So now
truncated.
that the AG is appealing,
Yes.
and he's going to appeal to the Supreme Court.
To the Supreme Court.
Will
Until,
that trigger, or they have to wait until the Supreme Court hears?
yes, so depending on the outcome of the Supreme Court, if the Supreme Court set aside the Court of Appeal decision and establishes or says that, okay, the trial court was right,
Then they will now have to go back to
they
where
would have
were.
to go back to the High Court. Now,
Oh, Lord.
it depends on the stage. Would the Supreme Court say the trial should start de novo,
Oh, Lord.
or they should continue from where they ended?
So that's
And
another matter that
that's another matter that we would have to look at. Now, in between, whether or not the Attorney General, because as it stands now, there are no charges. So you can't do anything. Any of them can decide to travel and not come
So
back.
you can't even hold them.
You can't hold their passports. Like Mr. Jakpa was going for it. You can't do anything against them. And so...
And already the CG has told us that Supreme Court has a big case load. So they are very busy.
whether or not it will be heard at what point in time.
Because they've said that they have a lot of cases.
Yeah, over 800 or so.
So this one, and then there's also an election coming. So but we can't take the politics out of this, right? Because even the public's perception of this is very politicized. So it's almost like whatever you decide, people will feel that there's politics involved.
behind. Unfortunately, yes, that is what it seems
Wow.
that it is. Yeah.
But thank you for speaking to the matters. I appreciate your time, Bobby. Sounds like Bobby Brown, Bobby Bunsen, and of course, Justice Ramsay. We hope you've learned something. Look, I said earlier on the radio, and I want to agree. I think we should pay judges more money, but we shouldn't give them the sirens, because reading the 100 and something pages, it was a lot of work. And look, we need to support them to do good work. And they are very important in our democracy. And they also have to be objective and fair. I think that's how we end it. So thank you, Bobby. Hopefully one day you become a judge. Who knows? I will just be on air. We'll see you next time. Have a great evening. Bye-bye.